two sets of homeowner association governing documents are written the same. This non-uniformity is due to numerous factors, primarily being the many different attorneys drafting governing documents and the differences between each various homeowner association. Statute changes can alter or effectively make a provision of an association's governing documents invalid. This is especially important considering that homeowner associations are a popular target of legislation. For example, in Arizona, the state legislators eliminated the use of proxies for annual meetings. This elimination of proxies was replaced by the implementation of absentee ballots. Covenants, conditions, and restrictions. These are also known as CC&Rs, master deeds, or declarations of covenants, and other similar type names. By what other name or abbreviation, these are written rules, limitations, restrictions on use mutually agreed to by virtue of purchasing in a homeowners association by all owners within the homeowners association. CC&Rs may prescribe exterior home colors, pets, ages of residence, parking, and other conduct in order to protect the quiet enjoyment of all the various members of the association. CC&Rs are generally enforced by the homeowners association and in extreme cases by individual members who bring legal action against other association members or boards of directors. CC&Rs run with the land and are thus permanent for all practical purposes so that future owners are held to the same restrictions and standards. CC&Rs are filed with the Register of Deeds in the county in which their association is located, typically. Articles of Incorporation are the fundamental charter of a corporation, in this case of a homeowner association, a non-profit corporation. This spells out the primary name, primary purpose, and the incorporators. Articles must be signed by the incorporating person or persons or by the first board of directors. The starting point for filing and approval of articles of incorporation is usually the Secretary of State in which the association is located. However, not all homeowner associations are incorporated. Bylaws are the written rules of conduct for the homeowners association. You will hear them also referred to as the rules of the assembly. In short, these documents tell you how the association is to be governed. They should not be confused with the articles of incorporation, which usually state the basic outline of the organization or corporation. Bylaws generally provide for meetings, elections of board of directors and officers, the filling of vacancies, notices, types and duties of officers, committees, assessments, and other routine conduct. Bylaws in effect a contract between the members and must be formally adopted or amended by the members. Bylaws may or may not be required to be on file with a government agency. When the term rules of the assembly is used, in most cases this is referring to the association's bylaws. However, the declaration of covenants and articles of incorporation can have rules of the assembly as well. However, generally speaking, the rules of the assembly and bylaws are the same written instrument. The board of directors generally has the authority to establish reasonable rules and regulations. This authority is typically found in the CC&Rs. These rules and regulations may provide for imposition of fines or penalties for violations of the CC&Rs. While I mention the rules and regulations here in context of the association governing documents, these documents do not play a role in the annual meeting. It is also noted here to distinguish that if someone uses the term rules of the assembly, this document is not what they're referring to. In most cases, they would be referring to the association's bylaws. Board resolutions are a method of documenting decisions made by an association's board of directors on behalf of the association. After a resolution is passed during a meeting, a formal resolution document is drafted to be used going forward to enact the specifics of the resolution that was passed. Board resolutions typically play no part in most homeowner association annual meetings. However, there may be certain resolutions in place that deal with procedural issues around the annual meeting process, such as a resolution on how long ballots from the annual meeting will be maintained before being destroyed. Procedural issues of a more substantive manner are best dealt with an amendment to the bylaws of the association. Board resolutions are typically not appropriate as an instrument to circumvent the bylaws or the rules of the assembly. In other words, the board typically cannot just pass a resolution if there is something in the rules of the assembly or bylaws that they do not wish to follow. The association's attorney should be consulted if there are questions about the ability of a resolution to be valid as it relates to the other governing documents.